If you're planning to apply for ILR, you need to make sure that you meet several requirements. So there are 3 most important rules which we will discuss in this video. Rule number 1. You must have lived in the UK continuously for at least 5 years. During this period, you cannot have spent more than 180 days outside the UK in any 12-month period. Now, when I say 12-month period, that means, for example, you got the skilled worker visa in 2024 January. So from January to next January, you should not have spent more than 180 days outside the UK. There are some exceptions apply. Watch this video. In this video, I have explained what are the exceptions, what documents you need to provide them to prove that exception, and how many days you can live outside. It's a complete guidance. You must hold a valid skilled worker visa at the time of your ILR application. Let's suppose you have spent 5 years in the UK with one employer. Now, just before your 5 years, your skilled worker visa is finished or your employer asks you to leave the company. You cannot apply for ILR because you don't hold a valid work visa, because your sponsored has cancelled your visa, but you have already spent 5 years in the UK. Because you don't hold any valid skilled worker visa, you cannot apply for the ILR application. Rule number 2. You must have ongoing employment with a UK employer who holds a valid sponsor license. Let's suppose you have spent 5 years with the company and now the company license is revoked and you don't have a job, so you cannot apply for ILR. Your job still has to meet the skill level. The skill level which we have just discussed in our other video, that higher skill, medium skill, that's what we are talking about. Further, it says and salary requirement for settlement, and you will need to pass the Life in UK test, which assesses your knowledge of British customs, traditions and history. Now let's discuss the rule number 3. For ILR, the English language requirement is set out in Appendix Knowledge of Life in the UK and follows the level requirement by the visa route under which settlement is being sought. This means that skilled worker ILR application submitted before 8th January 2026 will continue to require English at B1, while those submitted on or after that date will need to be B2. Further, the guidance says there is no retrospective effects. Individuals already granted a skilled worker visa on the basis of B1 qualification remains compliant with the conditions of their leave and are not required to retake test mid permission. If they apply to extend or settle after 8 January 2026, they will need to show that they meet or have already met the higher B2 standard. Further, the guidance says all ILR application must meet the suitability criteria and not fall for refusal under the general grounds of the immigration rules.